you have any comments or questions, please do feel free to add them to the chat box or raise your hand during the question and answer session. And now I will leave the floor to our very first speaker, Atharva. Floor is yours. You can start.
Hi. Thank you, Aigul. Thank you for the invitation to participate in the workshop. It's been a wonderful experience so far, and I'm looking forward to the presentation. So I'll just share my screen. Are the slides visible? Oh, terrific. Hi everyone, my name is Atharva Sontake and I'm a lecturer at the Jindal Global Law School in India. And the topic that I'm going to speak about today is about constitutional identity in India and the role of transformative constitutionalism in that project of constitutional identity, so to speak. So before diving into the question, I think the picture on the first slide really helps me to set up the question that I want to ask. And I've used it as a metaphor for the larger question that I intend to pose. And the picture is that of the original copy of the Indian Constitution, and specifically of Part 3, that is fundamental rights. And in the original copy of the Constitution, you can see that wonderful design. And that design actually or depicts a scene from one of India's oldest mythological epics, the Ramayana, right? And I'm using that picture specifically because I think it's a wonderful metaphor that helps me to get to the question that I want to pose, which is that if you go back to the point when India secured independence and when the constitutional drafting was happening, India as a society had diverse inheritances, so to speak, at the same time, right? So one was this pre-colonial inheritance of diverse religious, social, ethical, native indigenous traditions, right? And at the same time, there is this colonial inheritance of the various laws that were the precursors to the Constitution of India. And subsequently, post the enactment of the Constitution in 1950, you have had diverse influences in terms of constitutional reasoning, which have essentially come in from what you can call the global liberal constitutional model, so to speak. So, given these diverse inheritances and diverse influences, what can be said about Indian constitutional identity as of now? That is really the question at the heart of my presentation. So before diving into some other questions, I just want to clarify as to what I mean when I use the word constitutional identity, and I use it pretty much in the sense in which some of previous scholars have used that. In the sense, especially that Gary Jeffrey Jacobson has used constitutional identity as something that emerges dialogically and represents a mix of past inheritances of a particular nation, of a community, and also the political aspirations and the commitments which are expressive of those political aspirations of community that the Constitution represents. So it's in that sense that I use the term like I just want to maybe set up or explain some of the contemporary scholarship that has tried to answer this question of Indian constitutional identity. And that scholarship essentially talks about the concept of transformative constitutionalism and the Indian constitutional identity as a transformative one. Now, the concept, of course, originates in South African jurisprudence, and it was first enunciated by Clare in the famous article Legal Culture and Transformative Constitutionalism, where the concept as was understood meant that the constitutional project is not merely a project which envisages to limit arbitrary state power as standard liberal structural constitutions do, but that some constitutions envisage something far greater and beyond just that, which is a complete transformation, a social and political transformation of the country, of the community where that constitution is in fact being enacted. And some of the recent scholarship from India, especially Gautam Bhatia's book, The Transformative Constitution, where he provocatively titles his prologue as The Past is a Foreign Country, where he puts forth this argument that uh, the Indian Constitution is a transformative one uh, which seeks to initiate the Indian masses, so to speak, to the language, to the vocabulary of liberal constitutionalism, right? The triad of liberty, equality, fraternity, to build a constitution, to build a society on the basis of those identities, of those concepts, right? So Madhav Khosla also in his wonderful book, India's Founding Moment, talks about the constitution as a pedagogical tool which envisaged to create these new identities on the basis of liberty, equality, and fraternity, as opposed to a pre-colonial or a colonial society which had its identities deeply rooted in tradition, various social norms, which was a deeply hierarchical society. So this kind of answer to the question as to what constitutes India's constitutional identity takes the root of transformative constitutionalism, right? And my core argument really in this presentation is that transformative constitutionalism as a project of defining or creating constitutional identity may be a post-colonial one, but feels to be decolonial, meaning in the temporal sense of the word post-colonial, it does indeed envisage a complete break from the colonial past, so to speak, from that colonial inheritance. However, in its attempt to do that, I argue that it still clings on to the epistemological and the conceptual framework of Eurocentric coloniality stroke modernity, right? Which is why it fails to be sufficiently decolonial, but it is post-colonial in the sense of the fact that the state or the power has shifted from the colonizer to the native population. But the reasoning, the constitutional reasoning, the legal reasoning is still very much embedded within the epistemological framework that is derived from Eurocentric coloniality, modernity, and inevitably influenced by principles of global constitutionalism, so to speak. So very briefly, I just want to give a couple of examples as to how the Indian Supreme Court has tried to articulate the concept of transformative constitutionalism. And these are two rather recent judgments of the Indian Supreme Court. The first one was the landmark judgment where the Supreme Court decriminalized gay sex in India, right? Navtej Johar versus Union of India. And it's here where the justices have invoked the notion of a transformative constitutionalism, where they embrace the concept and say that the purpose of having a constitution is to transform society on the basis of ideals of justice, liberty, equality, fraternity. And they eventually strike down the Section 377 of the IPC, which was a colonial era law. And similarly, another colonial era law, which was the criminalization of adultery, was also challenged in the case of Joseph Shine versus Union of India. And the Supreme Court again embraced the concept of transformative constitutionalism or constitutional morality to basically strike down this colonial era law as well. And the terminology used by the Supreme Court is quite interesting because the justifications given to strike down some of these laws were that these colonial era laws have outlived their purpose. or that they have lost their rationale in today's day and age, and that they don't square with today's constitutional morality. So that so although one may not really disagree with the outcome, interest really is in the reasoning and interpretation techniques. The court primarily sees transformative constitutionalism as tantamount to some variety of social progressivism as dictated by trends in global constitutionalism, right? So in all these cases, you will see a lot of reliance on foreign judgments, foreign law, as to how law has changed in some of the other countries, basically the global north countries, which are basically trends in global constitutionalism, which have then been adopted directly through the use of transformative constitutionalism and constitutional morality. Now, uh, why do I critique that? Because I think, or I believe that these modes of reasoning are still very much embedded within the sort of the matrix of coloniality, modernity, so to speak. And I derive or I base my argument on the work that has been done by Walter Mignolo and Catherine Walsh on decoloniality, where the differentiation between colonialism and coloniality and decolonization and decoloniality, which is to say that although the formal transfer of power did take place in India way back in 1950, right when the constitution was adopted, uh, the epistemic forms of knowledge, of reasoning, which are essentially derivative of coloniality slash modernity, continue to find reflection in constitutional jurisprudence. First, as mm, through concepts of Christian theology, as we'll see in one example later, and subsequently as global constitutional trends developed, those aspects of secular sciences and secular philosophy have been directly incorporated in Indian constitutional reasoning as well. And therefore, the task of decoloniality really would mean to uh, have a complete epistemic reconstitution of some of these interpretative techniques that courts have been adopting. So it calls for a re-existence or a revival of indigenous and native forms of knowledge, ways of life, ethical traditions, right? So the epistemic framework, which I really criticize, uh, which underlies a lot of this reasoning that has come from global constitutionalism, is twofold largely. First is that a lot of the reasoning that is common really depends on what we can call a historicist approach to reasoning, which Dipesh Chakrabarty in his book Provincializing Europe describes as a universalist theory of progress, which is that Europe or Western modernity will show the way, show the moral way, so to speak, to the rest of the world, right? So first in the West and then elsewhere. That kind of historicist reasoning is very much embedded in some of these cases that Indian Supreme Court has decided. So that's first aspect of, you could say, a European or a Western coloniality slash modernity framework that continues to find reflection in Indian jurisprudence. And the second aspect, or the second epistemic forms of knowledge that underlie some of these reasonings, is what we can call normativization, which is to put some of these constitutional values which have come from uh, European modernity, to put them in a sort of a normative zone, so to speak, which is to say that those values, let's say, of liberty, equality, and the cluster of concepts that is usually associated with those concepts, like autonomy, dignity, right? That cluster of concepts now has been placed in a normative zone, which then serves as the guiding light for all aspects of society and social life, right? So all practical aspects of life, like politics, law, family, religion, all these institutions, all these practical aspects of life would now have to be reshaped in accordance with these constitutional values which have been put in this normative zone. And Gandhi, of all people, was deeply skeptical of the uh, modern legal project, so to speak, uh, was in fact one of the earliest voices to criticize this. And in fact, he argued that this kind of normativization does in fact lead to experience occluding structures, meaning that the native indigenous forms of knowledge, reasoning, ethical traditions, they somehow become inaccessible because a new vocabulary of modern law has now been instituted in a new post-colonial republic, so to speak. So I think these two deeper reasons or deeper forms of reasoning continue to find a reflection through aspects of global constitutionalism in the Indian jurisprudence. So, what is the answer? Is there a way out of this? I'll just present one example of a Supreme Court case which can show an alternative form of reasoning, alternative reliance on indigenous and native traditions and native epistemology, so to speak. And this was a case of Indian Young Lawyers Association versus the state of Kerala. And the question in this case was that there was this religious tradition of a particular temple which barred the entry of women of menstruating age. And the reason was that the temple has this tradition where the deity that resides in the temple has taken a vow of eternal celibacy, right? And therefore, this tradition of not allowing women entry uh, into that particular temple was a very long tradition. And the question before the Supreme Court was, does it violate the principle of equality, right? Now, as for Indian constitutional law, only those aspects of a religion are protected under constitutional freedom of religion, which constitute essential religious practices, right? Now, the problem with using essential religious practices test is that it originates or has very specific Christian origins because uh, it's only when you have a text that defines the core beliefs of a religion that you can distinguish between what is an essential aspect and what is a not essential aspect of a religion. Whereas if you look at the indigenous traditions of various strands of Hinduism, for example, there is no one book, there is no one set of beliefs, so to speak, that accurately or specifically define what constitutes one tradition as distinct from another one, right? So these indigenous traditions possess a very different character in the sense that these are orthopraxies more than orthodoxies, in the sense that the belief systems usually take a secondary role as opposed to practices, right? So the practice of the tradition is what matters. Therefore, you cannot go back to a book or to some treatise or to some text and look whether this practice was in fact sanctioned by the original religious text or not, so as to constitute essential practice, right? So that kind of reasoning has still continued, which is deeply colonial in its origin and does not take into account some of the nature of the indigenous traditions. Similarly, with the definition of what constitutes a denomination, right? Because under Indian law, if you have a separate religious denomination, the state cannot interfere in your religious practices. Here again, the concept of denominations has been derived essentially from the Christian conception of denomination, as opposed to how denominations or sampradayas, as they are called in native traditions, how do they understand the concept of denomination, right? And incidentally, if you look at the translated copies of the Constitution in native languages, the word sampradaya, which is more of an accurate descriptor of the native traditions, has actually been used, but somehow it does not find its way into constitutional reasoning, right? So some of these areas where there is a scope to revive some of these native indigenous forms of knowledge, traditions, I think can be the way forward where you can practice decoloniality through constitutional reasoning. So with that, I'll just conclude as I've already overshot my time. My conclusion is that transformative constitutionalism, although attempts to break from the colonial past, still continues to operate within the Eurocentric framework, which is firstly of Christianity and then subsequently of modernity, right? And decoloniality can be explored as an option to develop some autochthonous modes of constitutional and legal reasoning, although it is just one more option, and you need to perhaps do a lot of more work and explore how there can be symmetrical dialogues between some of the native knowledge frameworks and Eurocentric modernity as well. So with that, I'll just stop, and thank you so much, and I look forward to your comments and questions.
Thank you very much, Athara, for this interesting presentation. And now it is turn of Jessica.
All right.
You have 15 minutes, so it's your. Thank you.
Yeah, cool. I will briefly share my screen. All right. I discovered this option earlier. Here it is.
So just press share content.
So, yeah.
You will be fine.
Yeah, I did. Strange. Shouldn't it be happening?
Can you see that?
I'm sorry?
There's a button called share content. Can you see that?
Yeah. Well, the problem is I can't share the screen. I would like, now I can. I don't know why it didn't work. Sorry. Now you should be able to see the screen. Is that all right? Can you see my screen?
Yes.
Like
yes. Right.
A sort of blue-white presentation, proceduralizing indigenous representation. Perfect. All right. First of all, sorry for sort of apologies for sending this sort of late, especially Joshua commenting. Sorry, all error is mine. Well, I will have to run through this. Most of this is a bit descriptive for you to get some sort of view on things, and I hope to reserve some time at the ending for some sort of a conclusion, some more what I would deem more analytical stuff. So, all right, let's enter the first part, which is sort of which I called representation in indigenous façon. The paper, well, more broadly, let's give you at least a few sort of insights on what this is about. The paper examines question of indigenous collective forms of participation and representation as a permanent or transversal matter beyond the common ad hoc understanding of participation, which is usually based on specific impacts caused by extractive industries, infrastructure, or so-called development projects, which require free, prior, and informed consultation consent. Some of you might be familiar with this sort of big industry projects, and I would like to shift this focus a little bit and pay attention to a different fundamental issue. Well, two understandings stand out. Firstly, indigenous peoples broadly exercise political rights through their own institution and representatives as governed by indigenous law. And secondly, the right to collective representation in the state's operations and functionings, which finds accommodation under quota systems or legal pluralistic designs of the new state. And yeah, emphasis will be placed on the legislative dimension of this. So basically to be elected and to vote, to be elected more fundamentally. Developments in Andean states prove particularly relevant in that regard, owing to a shared history of colonialism and dictatorial regimes, common exposure to neoliberal agendas, resource demands, and related socioeconomic inequalities, subjection to a strong regional human rights framework, Inter-American System of Human Rights, growing civil society movements, and the continuing victimization of indigenous peoples and Afro-descendants, hence demanding a rebuilding of the state in its entirety. Most emblematic being the Bolivian and Ecuadorian plurinational states, recent constitutional reforms process in Chile, a strong Colombian constitutional court as the front runner of the region, and significant ad hoc developments in Peru, and very considerable participatory rights in the Venezuelan case. The paper distinguishes between and categorizes different spaces of articulation, procedures, and mechanisms, drawing on legal pluralistic theories, including indigenous accounts on institutionality, procedures, and decision-making, combined with classical constitutional avenues of representation embedded in legal political theory. This may allow us to derive at broader conclusions on indigenous autonomies and collective self-determination in the complex shared space of state governance. All right, let's get a little bit of taste of what the slide is actually about. I'm sharing. So the different sort of categories I was thinking of, well, based on sort of prior research and sort of a different sort of the literature, what the literature, some I would say relevant contributions are about, and fieldwork as well. So when studying, the first one would be indigenous decision-making bodies. And I think there are two variables which require further investigation, which are different spheres or levels of operation, such as local, sub-regional, domestic, regional, international. And the autonomy of indigenous organizations as opposed to larger political parties or affiliation with the latter. I think this tells us more about the sense of autonomy of decisions and providing sort of the infrastructure for, or the space for indigenous procedures and customs to find articulation. Secondly, sovereignty is considered a double-edged sword, as we have been hearing in previous presentations as well, being emblematic being the state-centric international law, including, unfortunately, international human rights law. We sort of critically assess the order or orders. And sort of the common associations with a harmonized or harmonizing state, also in the light of the decolonizing struggle for independence and liberation movements. Yeah, I think this is, we find sort of the roots in this in the Montevideo Convention, which is almost, I would say, 100 years old or something like that, very much based on and territorial integrity, external recognition by the international community. I mean, all this is something we can observe in many legal orders. They're, I guess, quite sort of controversial issues if we look at, for instance, at the question of Palestinian autonomy, right? So yeah, I guess there are many sort of illustrations of this, but I would say, yeah, indigenous rights, I think they deserve some thought. So all this actually becomes very much judicialized in Latin America. There's some literature on this, which I included. Thirdly, indigenous organizational structures and mandate holdership as traditionally subjected to external pressures, starting with the colonial age, which demanded representative positions to be in place. It is argued in some sort of accounts. And until today, leadership is particularly susceptible to corruption, bribes, as far as external representation is concerned. Fourthly, indigenous procedures may include customs, traditions, rules, and legal systems in line with UN DRIPS. You can find this in the UN Declaration as well as several references, interestingly, while acknowledging the diversity of procedures, such as consensual proceedings. And I know this part is, I would say it's a bit controversial. To what extent can you claim this to be universal, right, without essentializing? So yeah, that's a very common challenge, methodologically speaking, as well, I do admit. So yeah, consensual proceedings are commonly sort of reported to be representative in a way as a common process of traditional governance, operating at different levels among chiefs of particular nations and amongst clans at community levels or different levels, considering individual and collective concerns, including minority views. They're supposed to be less out of the level as well. Elements of cooperation and deliberative democracy, especially those interested sort of in political and legal theory, sort of the understanding sort of the principles, right, of specific sort of participatory state models, I would say. Oral traditions, and they're strongly bottom-up oriented. So basically, the mandate holder enacting who would enact a decision made by the people. And finally, accountability, not to be interpersonal, but rather towards understood as to be accountable, right, towards land and Mother Earth. I think this is also very interesting in terms of indigenous environmental rights, for instance. Let's switch back. Second one, if we understand this sort of in the legislative framework of the state, in terms of positive understanding these procedures as positive discrimination in the Andes, well, let's start with a very known case in that, I would say, in that regard, Yatama versus Nicaragua. So which concern the requirement to become a political party, which sort of disregarded, this requirement disregarded the customs and organization and culture of the candidates proposed by Yatama, an indigenous organization. So what does the court say? It maintains other ways to propose candidates need to be, and you can read this on the slides, those who cannot follow possibly, proposed candidates need to be promoted to encourage and ensure political participation of specific groups of society, taking into account the special traditions and administrative systems. Notably, the court argues, Yatama contributes to the consolidation and preservation of cultural identity of the members of the indigenous and ethnic communities. Its structure and purposes are related to the practices and customs and forms of organization of these communities. Consequently, the exclusion of the participation of the Yatama candidates particularly affected the members of the indigenous and ethnic communities that were represented by this organization. So that the right to be elected in a way was affected that way, right? The court calls upon the state to adopt all necessary measures to ensure that the members of the indigenous and ethnic communities can participate in equal conditions in decision-making matters and policies that affect or could affect their rights, so that they can incorporate state institutions and bodies and participate directly and proportionately to their population in the conduct of public affairs, and also to do this from their own institutions and according to their values, practices, customs, and forms of organization, right? Which is a sort of decisive detail. Let's see how this develops, and I'm planning to do some comparative analysis, but we'll stick to one order due to the lack of time. So there's the Bolivian constitutional order, and it's interesting, would be interesting to compare this to Ecuador and Venezuela. The Bolivian constitutional order establishes indigenous people's rights, both in their own terms, a dedicated rights catalog, as we sort of know possibly in other constitutions, as part of a general participatory right, and as far as the sort of constituency of the Legislative Assembly is concerned. Procedurally, the right can be invoked both individually and collectively, sort of opening up this whole standing debate, which it's interesting to compare with sort of the minority framework of the European Court of Human Rights, Council of Europe system. Secondly, the legislative power is to explicitly recognize indigenous peoples as a distinct group to be represented alongside political parties or groups of citizens. And there's a need for official recognition by the electoral organ. It is established elsewhere that indigenous institutions are considered part of the general structures of the state, while maintaining their political, juridical, and economic systems in accordance with their cosmovision. A very sort of integral view, right, which is adopted by the Bolivian constitution. So there's a recognition of internal self-determination, institutional recognition, the autonomy question sort of qualified by the state order, I would say. So there remains to be some sort of as was mentioned in the previous presentation, some sort of orientation towards the colonial order, right? As you would possibly argue. Thirdly, as far as the election of parliamentary deputies is concerned, indigenous peoples' proportionate participation shall be guaranteed. Indigenous peoples enjoy the right to select, designate, and nominate indigenous representatives according to norms and procedures. So there's some sort of differentiation between a quota system and outcome-oriented, which is rather the case in the Venezuelan constitution, and facilitating conditions for active and passive electoral rights in this case. Fourthly, where communitarian democracy is exercised, and I think that's quite an interesting term, meaning it's defined actually somewhere in the electoral law, means exercise through self-governance, deliberation, qualitative representation, and the exercise of collective rights according to indigenous people's own norms and proceedings. So whenever this is being exercised, electoral procedures follow norms and own procedures whenever such electoral rights are not subjected to universal suffrage. So again, there's some sort of limitation there. Let's see. So we can talk about possibly optimistic reading, following an optimistic reading, a shared space of participation, domestic constitutional system prevails in some way. Also interesting, as this would follow the complementarity principle, as some of you may be familiar with. And finally, there's some special electoral units of representation on the basis of population density in rural spaces and where indigenous peoples constitute populational minorities. Alternatively, these are determined by the law where population or geography-related aspects do not apply. Such units form part of the total number of deputies. So yeah, there's some sort of local quota systems addressing this sort of numerical minority question, locally giving weight to some form of in situ representation with larger implications, of course, in the sort of National Assembly. There are other questions, but I'm sort of already over time, I'm afraid, such as justice in legal justice systems, indigenous justice systems, and the so-called autonomias, autonomous sort of autonomies. So let's quickly see at least some sort of conclusions. So I will, I think I will just mention them very briefly. So there's standing rights and the relevance of collective identity. I would say these are, you can understand these as as part of an sort of comparative analysis, but also as some sort of proposal how to possibly influence policy making, possibly also constitutional reform, who knows. I think these are basic elements. Well, standing rights and are quite fundamental. Then there's sort of the positioning of autonomy and governance vis-a-vis the state. So it's not only self-governance, but it's also how this is being articulated in the state, such as the legislative, as I sort of described. legal personality, it sort of relates to standing rights, so the recognition of collective identity. Also in the sort of the shaping process of legal personality, who's actually determining how legal personality is being sort of formed or defined. Well, some sort of particularities of the right to elect and to be elected, which we don't have the time for, and well, some sort of proceduralizing of proceduralization. So how do we actually translate these indigenous customs into state law? Well, I think you got some taste of this, at least in the Bolivian constitutional case. Well, thanks very much for your attention and for your possible comments, possibly. Okay, sorry.
Thank you very much, Josh, for this wonderful presentation. Can you please stop sharing your screen, please? Can you stop sharing this? And then we will move to the last presentation of today by Pablo, Domingo, and Constanza. Floor is yours.
Thank you. Do you listen to me?
Yes, we can hear you.
We're very happy to be in this wonderful panel. We are collectively working on a paper on the topic we're going to talk today, and the three of us will present our work in a successive order. So to begin, Chile is currently undergoing a constituent process to replace the 1980 constitution, which is institutionally mediated by rules agreed through a constitutional reform. One of its peculiarities is the rule contained in the final paragraph of section 135 of Constitution, namely, the draft of the new constitution that is submitted to plebiscite must respect the republic nature of Chilean state, its democratic regime, final and enforceable court rulings, and international treaties ratified by Chile which are enforced. Several have pointed out that this rule imposes substantive limits on external nature on Constituent Assembly that will draft a new constitution. For this reason, some say that it's not really possible to speak of constituent power. In this work, in this paper, we argue that this is incorrect. We argue that it is important to keep it the concept of constituent power, and this concept is fully applicable to the Chilean case. As we all know, the idea of constituent power indicates the power the people have to create a legal and political order. Unlike constituent power, which is precisely limited by the rules that constitute it, constituent power has legal and limited nature. This is what gives it its transformative character. This, however, does not mean to assume the whole Schmittian theory of constituent power, which is especially problematic in that it assumes the preexistence of a people that can be identified non-politically because it shares a natural identity, such as ethnicity, language, religion, so on. The people do not pre-exist the constitution and therefore cannot be identified without recourse to institutional forms, and those institutional forms are representation and democratic participation. It is on this basis that Colón Ríos argues that constituent power must be exercised through a procedure that comes as close as possible to the idea that it is a people giving itself a constitution. In the same vein, Calibas argues that it is the immanent principle of the term constitute that prescribes that the foundation of a new constitutional order must involve those who are to obey it. However, if the constituent power requires a democratic procedure for its realization, it cannot abandon these presuppositions in the constitution that it institutes. As Colón Ríos states, the constituent power undermines itself when it violates the condition that makes it possible. That is, when it does not institute in the constitution democratic procedures and the principle of constitutional democracy, such as freedom of expression, assembly, and the right to vote. This is why the realization of constituent power must end up in the adoption of a constitution that guarantees the right and institution that makes democratic participation possible. In this sense, constituent power is not in significant tension with the essential principles and institution of the democratic constitutionalism. These, however, we argue, do not operate as a limit imposed from outside, but as limitation of an internal nature. The idea of constituent power, thus understood, illustrates well the problem of the 1980 Constitution and the constitution process that will eventually replace it. It is unquestionable that the 1980 Constitution was not a result of the exercise by the people of their constituent power. The 1980 Constitution was drafted by a group of 5 conservative and right-wing men appointed by the military junta, was subsequently ratified by it, and was approved in a fraudulent plebiscite in the context of a military dictatorship. This is why the problem of the illegitimacy of origin of the 1980 Constitution was always being present in the public discussion. But that's not the whole problem. It is also the anti-democratic character or content of the 1980 Constitution, which through locks or traps place limits on the institutional expression of the people. The force of the social process that exploded in October 2019 was what dragged the constituted order to open the way for a new constitution, a constitution not created according to the rules and principles of the constituted order that was being challenged, precisely challenged. It would be a constituent assembly with gender parity and representation of native people, directly elected by citizenship, which will draft a constitution subject to a quorum of 2/3 of the members of the assembly. The Constitutional Assembly will draft the constitution on a blank sheet of paper because the rules of the 1980 Constitution will not be there by default in case the 2/3 quorum is not reached in a certain matter. The question is whether the Constitutional Assembly Constituent Assembly will be subject to external substantive limits of legal nature. As we point out in the beginning, Section 135 established that the draft of the new constitution must respect the republic nature of Chilean state, its democratic regime, final enforceable court rulings, and international treaties ratified by Chile. In light of the above, it can be argued that the duty to respect republican character of the Chilean state and its democratic regime is nothing more than an internal substantive limit immanent to the exercise of the constituent power. My colleagues will argue that the duty to respect international treaties ratified by Chile is not an external limit as one might believe.
Thank you, Constanza, and thank you everyone for having us here. I'm going to talk about international treaties and the limits of constitutional change, specifically in terms of constituent power. International treaties do not establish obligations that limit the constituent power of the state, and that's without prejudice to the considerations that we will make with respect to its possible international responsibility. This does not mean that the international system does not exert pressure or influence on domestic law, but that such influence does not determine a relationship of validity between international and domestic levels. In other words, international law does not mandate the way in which states determine their constitutional charts. And for that matter, it's important to review a core international principle, political self-determination. States are free to define their own constitutional structure, arrangement of powers, and their own Bill of Rights as they see fit. This is a direct consequence of the principle of non-intervention established in Article 2 of the Charter of the United Nations, but also in Article 1 of the New York Covenants, the ICCPR, and the International Covenant on Economic and Social Cultural Rights. Also, states enjoy wide discretion in implementing human rights duties in accordance to their own constitutional process, as established in the ICCPR and the American Convention on Human Rights. It's important to note this because in Chile, some have argued that Article 27 of the Vienna Convention on the Law of Treaties sets a hierarchical order between international law and domestic or municipal law. And this text would compel a direct effect of international treaties with respect to domestic law in such a way that it is a primary rule that mandates the internalization of certain contents of a conventional matter. That interpretation does not follow from the text of the treaty. Article 27 establishes only a rule of responsibility, which basically excludes the invocation of domestic law as a legal basis for replacing or displacing the international responsibility of the state in breach of an international obligation. In similar terms, Article 32 of the Articles of Responsibility of States for International Wrongful Acts, elaborated by the International Law Commission, RCWA, it plays basically the same. So before addressing the issue of compatibility and incompatibility between constitutional new rules and international obligations, one should refer to the classic distinction between primary and secondary rules. This distinction, elaborated by HLA Hart, has been adopted by the International Law Commission in RCWA's rules. This distinction is central to the understanding of the problem of compatibility, incompatibility between domestic and international rules. Because it's not sufficient to refer to a subjective reading of the possible relationship between domestic primary norm and an international primary norm in order to configure the international responsibility of the state in the case of the exercise of constituent power. This could be just a sign, but should rest on the interpretation of the content of the primary obligation. The content of the primary obligation must be determined first to later be able to apply the elements of an international wrongful act by the state rule. If the state has wide discretion, as has been the case in terms of international human rights, such assessment cannot be easily made. And this is also particularly true under RCWA's articles because those articles does not have any saying on the content of the primary rules, such as the obligation of an international treaty, and is a body of standards that cannot be applied in the case of special rules of international law, such as in the case of the jurisdictional rules of, for example, the Inter-American Court of Human Rights of the Human Rights Committee. So if those considerations are correct, then it's easy to apply mutatis mutandi, James Crawford's cautious advices on whether the enactment of legislation, in this case constitutional rules, may or not may constitute a breach of an international primary rule. Crawford has said that there is no such thing as a breach of an international obligation in the abstract. Therefore, contextual approach, case-by-case analysis is always needed. Crawford does not rule out the possibility that the enactment of a legislative rule or constitutional rule may violate a treaty obligation, and he addresses the issue of uniform treaties. But that's not usually the case of constitutional rules. In most circumstances, and here I'm quoting Crawford's, the enactment of legislation or a constitutional rule may not in and of itself amount to a breach, especially if it is open to the state concerned to give effect to the legislation or constitutional rule in a way which would not violate the international obligation in question. In such cases, where there is a breach will depend on whether and how the legislation is given effect. In light of the above, the constituent power is not limited by international treaty, although its act could make the state liable under international law, but such conclusion can only be made in a case-by-case analysis. Thank you.
Thanks, Pablo, and thanks, Constanza. Let's go back to Article 135 then. So according to it, again, the text of the new constitution must respect international treaties ratified by Chile, which are in force. And this includes all kinds of treaties. By the way, the elephant in the room, everyone who has been in the Chilean press claiming that international treaties place limits on the Constitutional Convention have been resorting to free trade agreements and international investment agreements. Almost none of them have mentioned international human rights law. So the principal disagreement has turned around what it means that the new constitution must respect treaties. The main, although not exclusive, voice from international law lawyers is that this provision places a juridical, thus enforceable, substantive limit upon the decisions that the Constitutional Convention may take. This despite Article 136 explicitly states that the Supreme Court can only decide on procedural disputes and, I'm quoting here, in no case on the content of the text being drafted. The explanation of this agreement requires, we believe, a brief detour. According to the rules defining the constituent process, as Constanza mentioned, the Convention will draft the new Constitution from a blank page, or in Spanish, desde una hoja en blanco. In order to approve the rules of the new Constitution, the Convention must meet a quorum of 2/3 of its members. The relevance of the so-called hoja en blanco rests on the parochial discussion experience that arose in the context of previous attempts to replace Pinochet's constitution, in which the 1980 constitution was always proposed to operate as the default rule for all norms where there was no agreement on how to be replaced. So the principle today established in the constituent process, that the constitution will be drafted from a blank sheet of paper, means that there are no provisions of the current constitution that will operate as the default rule for the new constitution. So strictly speaking, it's all yet to be written. Now we can return to Article 135. Some voices have resorted to this principle of the blank page to present what they understand by the obligation that the Convention must respect international treaties. There have been two main positions. The first position claims that the duty to respect Article 135 assumes that the text of the new Constitution cannot breach international obligations as established in international treaties. That is, that the text of the new Constitution must move within the contours of the international treaties ratified by Chile. To stay with the idea, there would be a blank page, but on it could not be written something that would end up breaching the provisions of the treaties. The second position contends that by virtue of the provision of Article 135, then there is no longer a blank page. The Convention, this is exactly what has been said, would begin to work on a sheet of paper that already contains multiple provisions, which would be those of the treaties. A variant of this position has gone so far as to argue that the Convention has a positive obligation to include international obligations established in the provisions of the treaties into the text of the new Constitution. Not to do so, this position has argued, would be equivalent to breaching international treaties. As it can be seen in both cases, respect for international treaties is read as a juridical limit on the Convention. Our position is different. It calls for a more political than a strictly legal evaluation of constituent moments. What does this mean? And with this, we begin to end. First, we have an argument of principle. We argue that constituent moments demand a different assessment of the relationship between international law and the domestic law of states. This requires us to look at what kind of changes the states seek through drafting a new constitution. International law should consider the predominantly, if not exclusively, political nature of these moments and of the outcomes sought by states. Suppose that a state is transitioning from dictatorship to democracy, or pursuing a peace process, as in the Colombian case, or as Sarva just explained in the first presentation, a state wants to move to a transformative constitutional scheme, and that state has signed free trade agreements or ratified international investment protection treaties. Should that state be subject to international sanctions for adopting a domestic constituent decision that may secure that very transition to democracy or a peace process or a transformative constitution, but that may collide with those treaties? How much margin should we grant states in developing a constituent decision in face of their international obligations? Second, an argument from the practice of international law. We draw attention to the need of conceiving of international responsibility in less broad terms that the way internationalist positions, at least in Chile, have constructed it. In a nutshell, the determination of international responsibility requires the operation of the institutions of international law, and it is not something that simply arises eo ipso because of any inconsistency or apparent inconsistency between the decision of a state and the norms of the treaty. But even more so, the very determination of whether there has been a breach of the international treaty, just as with constitutional provisions, is far from being self-evident or non-controversial. Third, we argue that Article 135 establishes a competence delimitation between the power of the Convention to draft a new constitution on the one hand, and that of the other constituted powers that maintain their regular power on the other, of course, until the new constitution is enacted. This means that the convention, at least from a political constitutional term, is not limited by the provisions of the international treaties signed and ratified by Chile, but neither can it denounce those treaties because this is attribution currently in the hands of the President of the Republic and the National Congress. Last but not least, an argument of transnational, let's call it transnational responsibility and respect. We do not claim international treaties should not be relevant or observed or considered or even serve as a guideline for the work of the Constituent Convention. What we do argue, however, is that the determination of how these international law obligations will be translated into the new constitution is a matter for the convention itself to decide. In other words, it is the convention and not a jurisdictional instance that will determine how the obligations of the international treaties that Chile has signed and ratified will be read, interpreted, and incorporated into the new constitution. Of course, none of this prevents the state of Chile from incurring in international responsibility. As we said before, the regular operation of the institutions of international law, whose function is that of deciding whether there has been a breach of international obligations or not. However, and we return here to the first argument of principle with this, that responsibility, this is what we end up claiming, must be evaluated in political and not strictly legal terms. It is, after all, a constituent moment. Thanks for your time, and we are more than happy to hear your comments on our work. Thank you.
Thank you very much for your wonderful presentation. And now I will leave the floor to Jo for her comments and feedback on all these 3 papers.
Thank you very much. Thank you to all of the speakers. I don't have a. Well, I said this last time. I said this morning that I didn't have too many comments, but I probably did have quite a lot of comments then. But I've had 6 papers to comment on today, so that's somewhat. That's given me an interesting challenge, but these are fascinating and many of them right up my street. But of course, I'm not by any stretch of the imagination really experts really in anything in any of these specific areas. But the Otava's paper, where I'm really relying just on his presentation and his abstract, because Otava hasn't been able to send us a written paper. This is a fascinating and I think very productive project, Otava, and it will be interesting to see it brought more into conversation with Sebastian Rudas's paper on indigenous peoples and multiculturalism, because he had a different and political philosophy take on some of the same questions, and it would be very interesting to see those questions brought into conversation with each other, which also means that one of my points, as it were, right now is simply to reiterate that it would be perhaps quite a good idea if a number of people contacted each other by or multilaterally, because there are so many areas where papers are speaking to each other, and I'm sure it can't be either hard to get hold of email addresses via IGON or on the web and so on, but there are some really interesting analogies there. I found your discussion of constitutional identity and the proposal for the recovery, if you will, of certain forms of knowledge very interesting. I've tried to think a little bit about this in the context of citizenship, and there, that you run into the issue. Well, maybe not so much in India, but in some parts of the world where there have been colonial superstructures imposed and so on and so forth, the actual recovery of knowledge and understanding from pre-colonial times is almost impossible. I think in India, having been obviously a highly literate society and a highly prosperous one until the attentions of the colonizers, is a very different type of case, and you know, the way in which you're trying to suggest there may be possibilities of interweaving different forms of knowledge is potentially very productive. I didn't get a sense that you gave us a way forward, but maybe that's because you haven't quite got to that stage in your research. But if you wanted to comment on that in Q&A, that would be excellent. Jessica, it's fascinating to see all the material that you've gathered together, really as a sort of a bottom-up counterpoint to some of the perhaps the more top-down types of papers that we've been listening to in the last 2 days. I learned a huge amount from looking at your work there, your abstract, your presentation, and so on. About the variety of different institutional structures, and there, I suppose, in a way, then we're looking for ways of actually understanding those structures, and therefore what sort of types of principles, and then is it placing, as it were, constitutions in question in the way that Tava's papers saying, well, actually, how can we get beyond the or how can we get the decolonization of the constitutional framework in that context? Now, the final paper I think is an absolutely fascinating and very fully worked through excursus into as you call it, the use and misuse of international law in Chile's constituent process. I think the world is fascinated in looking on in fascination, and I learned a huge amount from reading your work here, and I haven't really had the time to fully absorb it. It deserves a great deal more than in terms of attention. I think I would have a couple of questions for you in terms of thinking about if you were going to submit this to Global Constitutionalism in a similar way. One is that we have actually published something on the previous neoliberal constitutional process of Chile by a guy called yes, you're nodding, you know about it, but I don't think you referenced it in your paper as yet, but maybe it's something you've dug out more recently, or maybe it's there and the PDF finder didn't find it. So you obviously know about that, yes. So Jonathan's point about situating yourself in the context of the corpus of work that we're already curating in Global Constitutionalism over a series of years is well taken. The second point was also to reiterate one of Jonathan's points, which is, you know, your work has quite a strong slant towards legal scholarship, towards constitutional law, towards legal practice, international law. Just to think about our reviewing process potentially, that your paper is likely also to be reviewed by someone from the field of international politics or international relations, and how might they understand those very difficult relationships that you discuss in extenso there, as to how one understands the role of international law in constitution making processes. And then one final point is really to ask you whether you're cognizant of some of the work of Tamar Hostovsky-Brandes, who published a paper relatively recently, and I think it might be an Icon, where she's done some. She's worked quite hard, I think, to figure out where cases of I think it was her, or maybe I'm confusing it with something else. Anyway, I've seen a paper somewhere, and I will try to dig it out, where someone has gone through and ascertained that reductions in constitutional court citations to international sources is a harbinger of increased grip of a populist perspective upon the country, and I think that represents quite an interesting sort of an interesting counterpoint to some of the other work that you've cited on the interaction between international law sources and constitutional or constituent power, if you will. So just something for you to maybe think about there. So then there we go. I'll switch myself off again.
All right. Thank you very much, Joe, for this comment. And now it's time for you all to react to Joe's comments if you have any thoughts. So we can start with Atara. Do you want to add something?
Yeah, sure. First of all, thank you very much, Professor Zhou, for your comments. The one point that you mentioned regarding what could be a possible way forward is something that I completely agree with you in the sense that this is a work in progress. I haven't gotten to the point where I can suggest concrete ideas as to how to move forward. But I think one area of law, especially in India, which is quite susceptible to a more decolonial approach, is perhaps the area of law and religion. Because there is a lot of indigenous literature uh, on India's native religious traditions, which I think will benefit a lot to the way constitutional courts in India have been approaching aspects of religion and traditions, so to speak, and evaluating them uh, on the anvil of constitutional values. So I think that is an area which perhaps has some scope where some work can be done. So I think that would be perhaps an area I would like to focus on to take this project forward. Uh, so that's about it. I think thank you for all the other comments as well. I have taken all of them on board. So thank you very much.
Thank you. And now, Jessica, do you want to add something?
Yeah, thank you. Don't want to take the space. Well, thanks for the appreciative comment. Yeah, I suppose with all this sort of discussion of procedures, which I do think these sort of technical issues at times are very revealing and this in terms of what actually indigenous autonomies and procedures, how they actually find a way or they don't find a way into the decolonize the sort of state in Bolivia. I mean, with very optimistic, I suppose, optimistic reading. Yeah, I suppose the Andes and there's actually work on this. Sort of more sort of transversally sort of viewing these issues. Irigoyen Fajardo and Gargarella, they've been sort of tracing, and others as well. They've sort of been tracing these developments in sort of different phases, and I think that's a very sort of exciting way of viewing this. And well, I think by means of these procedures, that's at least one, in my humble opinion, one way of disentangling this a bit further, sort of identifying sort of the roots of this. Most essentially, this is happening right now in Chile, and I think it's very interesting, and I would like to this sort of constitutional moment you've been talking about, and also in sort of articulating this relationship between the people, the state, and international law. I think that's extremely exciting to examine. I would be very happy to read your paper. I've actually worked very recently on the Norin Cataliman case, and sort of also understanding sort of different sort of influence of international law. It's actually sort of under review at the moment. I would like to very much get in touch and possibly sort of work on this matter and a collaborative exchange papers and stuff, if you like. Well, that's all for me. Thank you.
Thank you very much, Jessica. And the last presenters, Pablo, Domingo, and Constanza, do you want to react, to add any thoughts you have?
I'm going to jump just right in concerning international politics and international relations. I think it's a great comment. This is the first raw draft version. We do use the notion of iterative interactions between the domestic level and the international level, taken from Sayla's Ben Habib work. And we do think that a dialogical way of understanding how international obligations play a role in constituent processes should take notice not only from the epistemic indifference between both domestic legal orders, has been established long ago in international responsibility doctrine, but also on how they interplay both in terms of influence, impact, and political assessment when enacting new constitutional rules. So I think that it's a fascinating question, and we do need to add more on that to make it more fully. But anyway, what we want to focus is on the juridical or the legal side or aspect of this, because the controversy in Chile is whether Article 135 can be or cannot be enforced as an external limit to the constituent power ongoing. So, but I think you're completely right, Joe. Thank you for that comment. We're going to add some more political relations, international politics and international relations literature to sum up on that aspect of the work. Thank you.
If I can add something just on the populist debate, in Chile, and this is something you can actually read in Jonathan's paper. The populist tag has been used every time someone is trying to advance an idea against mainstream economic global capital principles. So, as Jonathan says in his paper, Chile was used as a kind of laboratory to implement neoliberal constitutionalism, and this process that is current unfolding in Chile is a reaction against that model of constitutionalism, which has severely impacted in the lives of the people. So we all of us have worked with international law. We have litigated internally and externally using international human rights institutions. But our concern today is that the tag international law has been used by conservative positions, by right-wing scholars, to try placing some limits on the work of the constituent process. Just to speak with Atharva, we believe, I think, that we are trying to unfold a transformative constitutionalist process, and the use or the misuse of international law in this case is on the hands of those who have been trying to put legal limits on the work of the Constituent Convention by claiming that free trade agreements and investment protection treaties are also as important as human rights treaties. Our concern, of course, is with the latter kind of treaties. Constitution do enshrine fundamental rights, to protect human rights, but constitutions are not the place where you are protecting investments or where you want to promote a certain kind of economic model. They may have some impact on those areas, of course, but this is not what they do. So this is our claim, and I think, and thank you very much for the comment, Joe, that we should be more explicit in our appreciation of international human rights law, because all of us have been, as I said, litigating on the ground here and abroad for the implementation of international human rights law. But then we have this sudden concern for international law, which go hand in hand with the protection of a certain kinds of international treaties. Thank you so much.
Thank you very much for your thoughts. It's great to hear them. So now I see Antje has raised her hand. Antje, please, if you want to join by unmuting yourself. And
yeah, okay. Hello, everybody. I hope you can hear me. Sorry, I'm a bit subdued because I got my second jab today. So I'm a bit drugged, but nonetheless, thank you very much for these interesting papers. And I can only echo what Joe just said, that many of the papers at the workshop really speak to each other, and there's a really nice comparative element to it. I have just a suggestion or a question perhaps for Atharva. And that's, I wonder whether you are familiar with the work on transformative constitutionalism in Latin America by Armin von Bogdandi. It's actually, there's no place where I can write something into the chat. So that's, otherwise I would provide you with the reference.
The chat seems to have got disabled. I think as something changed about Teams,
Yeah.
it looks different. They're always changing these things.
Yeah, the book is called Transformative Constitutionalism in Latin America, The Emergence of a New Jus Commune. And it's by Armin von Bogdandi, Eduardo Ferra McGregor, Mariela Morales Antoniazzi, Flavia Piovesan, and Ximena Sole. And it's with OUP. And I thought, oh, there we go. Somebody's holding it up. Jessica, you got it. Okay, that's good. Yes, I thought that is a very strong book, and it's outstanding in the way that it takes a kind of a political approach to improve constitutional values, and that's kind of a move, a significant move towards something new. And I think it would be very nice in support of your kind of, you know, the Chakrabarti argument that you make as well. Well, so that's all from me. Thank you very much.
Thank you very much, Ante. And also, Ante, if you want, we can provide them by this comment, and I mean the book itself. You can send it to me, or I can send them by GlobeCon address, please, because I don't know. There's a problem with the chat. I just noticed this.
Yeah, I'll send you the link, Aigun. Okay, I'll do it.
I will send to the presenters. So thank you very much for this. And now I see Madhavi has raised her hand. Please, Madhavi, do you want to add something?
I had a quick comment for Atharva's paper again. I found it intersecting with different areas of my own areas. But one was to be careful in distinguishing between the use of native or indigenous versus Hindu or something like that, because I noticed in terms of the Sabrimala case, Young Lawyers Association, that we talked about the indigenous folks, but what's talking about there is a Hindu caste. So I think that's really important to distinguish between the two and be clear about what form of discussion. And also, secondly, I think I know in Hindu that it could be useful to look at the Constituent Assembly debates and the constitutional documents that preceded but and to understand the kind of constitutional independence movement that happened and see whether that movement really had the space for indigenous or local modes of those were my two comments.
Yeah, thanks, Madhavi. I got your second point, but I think there was an audio issue with the first point you made. I couldn't hear it properly. So could you just repeat the first point?
Can you hear me better now?
It's much better now.
Yeah. Okay. So my point, the first point was just to be careful in distinguishing between, the use of your terms, because you use indigenous quite a lot, but it does seem, by your reference to the Sabrimala case and I mean the Indian Young Lawyers Association case, that you might be conflating it a little bit with Hindu, and those are Hindu traditions and customs and reasoning. So I would suggest at least to make that distinction clear and to be clear about what you mean when you're saying indigenous, because to me those are two completely different things in the Indian context.
Yeah, I got that. Thank you for the comment. I'll definitely consider making the terms more clear.
Right. Thank you very much, Madhavi. And now I see Gaurav's hand raised, but I just want to let you know that we have just a bit of time left. So if you keep it very short, that would be much more appreciated.
Yeah, sure. Yeah, I think my comment is for Atharva as well. I think there's a very live debate going on at the moment about the place of liberal constitutional precepts, institutional and moral precepts, and its application to places in the global south. And I think with your scholarship, it would be good to place yourself somewhere within this existing debate about whether an approach to constitutional transformation in countries in the global south requires an abandonment of some of the precepts of liberal constitutionalism or not. So that's just a quick point. Thanks.
Thank you very much, Farah, for this comment too. I don't see any other question or, raising hands here. If you want to add something, please let us know. Otherwise, I think we can wrap up. Joe, should we wrap up, or do you want to add something as the chair of the session?
No, I'm fine. It's been a very fruitful 2 days, so thank you very much to all of the paper givers, both in this session and the previous sessions, and for the many different questions that have come from lots of people on the call, and really encourage people to communicate with each other bilaterally and multilaterally over their projects, because so many of them speak to each other.
Right. So we can now close the event. So it was a really great event. I think all have hopefully enjoyed these 2 days. So thank you all for all these great presentations, wonderful contributions. And as you know, we said before, our aim is to build your network with us. So please feel free to send any inquiries to our GlobeCom address. We will be replying them, obviously, and we look forward to hearing from you, also your submissions, hopefully. So take care. Thank you for being here. Bye-bye.
Cheers.
Thanks so much, everyone.
Much.
Fantastic
Cheers.
set of
Bye.
papers.
Bye.
Nice to meet you all. Bye-bye. Be well.